Ever get that feeling that even if your business seems like it's firing on all cylinders, there might be something unseen lurking, something that could just throw a wrench in the works?
Mm.
We're talking about legal risk, and believe me, it's not just for the legal eagles to worry about.
Not at all.
Whether you're running a lean startup or you're heading up a huge multinational, understanding this stuff, well, it's like having a secret weapon for success and for avoiding some seriously nasty surprises down the line.
Exactly. And today, we're going to try and unlock that secret weapon. We're taking a deep dive into a really valuable resource, the ISO 31022 standard. It basically gives you the roadmap for managing legal risk effectively.
Right.
Our aim isn't to turn you into a lawyer, though. Not at all.
No, definitely not.
It's more about pulling out the essential insights, the kind of aha moments that will empower you, the listener, to make smarter, more informed decisions for your own organization.
Okay, so let's start with the basics then. When we talk about legal risk, according to this standard, ISO 31022, what exactly are we looking at?
Well, the standard defines it pretty broadly. It's any risk that stems from legal, regulatory, and contractual issues.
Okay.
But what's really key to grasp here is that it also includes risks from non-contractual rights and obligations.
Oh, okay.
The core insight, I think, is that it's not just about, avoiding lawsuits. It's really about understanding the entire legal landscape that can impact your strategic goals, your operations, everything.
Non-contractual.
Yeah.
That sounds like maybe a less obvious area for some people.
Yeah.
Can you break down what you mean by legal, regulatory, contractual, and then maybe give us some real-world examples of those non-contractual risks?
Sure, certainly. So legal matters cover the big picture, national and international laws, court decisions, case law,
Right.
and the rules set by government agencies, administrative acts. Then you have contractual matters, which are about your formal agreements.
The paperwork.
Yeah, exactly. Think about maybe not meeting your obligations or struggling to enforce your rights under a contract or even just being stuck in a really bad deal, what the standard calls an onerous contract.
Now, for the non-contractual side, risks from non-contractual rights could involve things like failing to properly protect your intellectual property.
Like trademarks or patents.
Exactly. Your brand names, inventions, creative works, and then risks from non-contractual obligations. Well, they might arise from your duty of care to others.
Duty of care.
Yeah, like maybe mishandling customer data and falling foul of privacy laws, or even, a careless social media post that leads to a defamation claim.
Wow. Okay, so it's way more encompassing than just making sure you're ticking the right boxes and filling out forms.
Definitely.
Now, the standard keeps mentioning the importance of understanding the context. What does that actually mean when we're talking legal risk?
Context is absolutely fundamental.
Yeah.
The standard looks at it in two parts, external and internal.
Okay.
The external context is all the stuff happening outside your organization that can influence your legal risks.
Like, think about the specific laws and regulations that apply to your industry where you operate. Locally, internationally. Are those laws changing? What about industry bodies? Unions?
Stakeholder expectations too, I guess.
Absolutely. Customers, government, the media even. Also, actions by third parties like fraud, maybe international treaties. It all comes into play. And for businesses operating across borders, this gets really complex really fast. You've got different legal systems, different cultural norms.
Oh, yeah.
And sometimes your home country's laws can even have implications elsewhere. It's like navigating a maze where the walls keep
A
shifting.
little minefield, it sounds like.
Yeah.
Okay, what about the internal context? What should organizations be looking at inside their own four walls?
Good question. The internal context is about your organization's own characteristics,
Right.
And how they shape your legal risks from the inside.
Like the type of company you are.
Exactly. Are you a partnership, a public company? Your financial stability matters. How your business model works. What's your internal legal structure like? How's the company governed?
Your ethics policies.
Yes, your code of ethics, any past legal troubles you've had, the intellectual property you actually possess, all the contracts you're currently in. These all contribute.
Okay.
Even your internal policies on how you manage legal risks are part of this picture. Essentially, it's about understanding your organization's, let's say, legal DNA.
Okay, so we've laid the groundwork. Now, the standard talks about some core principles.
Yeah.
Things that should guide how you manage legal risk. What are the big ones we should keep in mind?
Yeah, it adapts the main risk management principles from the big standard, ISO 31000, and tailors them for legal risk. One really crucial one is that legal risk management needs to be integrated.
Integrated, meaning?
Meaning it shouldn't be this separate thing your legal department does off in a corner somewhere.
Right. Not a silo.
Exactly. It needs to be woven into your overall governance, all your management processes, from big strategic decisions right down to daily operations. The core insight here is legal shouldn't be an afterthought.
Yeah, I can see that.
Imagine, say, a product team launching a new feature without thinking about data privacy. That's what happens when legal risk isn't integrated.
Yeah.
It needs to be part of how you manage compliance, safety, quality, everything.
Makes total sense, like trying to bake a cake and forgetting the flour. What else is fundamental here?
Another key principle is your approach needs to be structured and comprehensive. You need a consistent way of looking at legal risks right across the organization.
Okay.
It also needs to be customized, tailored to your specific situation. What works for one company might be totally wrong for another.
Right.
Your legal risk management has to fit your unique external and internal context. That includes really understanding the potential impact if you don't comply with laws and actively looking for ways to keep legal costs and complexity down.
Proactive, then.
Very much so. The standard also emphasizes being inclusive. That means involving the right stakeholders in the process, while of course being very careful about maintaining legal privilege and confidentiality. That's crucial.
Involving stakeholders. Yeah, it sounds like it could get complicated when you're dealing with sensitive legal stuff.
It's definitely a balancing act for sure. Another vital principle is being dynamic.
Dynamic. Meaning it has to change.
Yeah, the legal world isn't static, right? Laws change, regulations get updated, so your approach needs to be able to adapt, maybe even have ways of anticipating potential shifts.
Okay.
You also need to make sure you're using the best available information. That means tapping into your internal legal expertise, using business intelligence, looking at legal databases, and not being afraid to bring in external advisors when you need that specialized knowledge.
Right. Leverage all resources.
Absolutely. The standard also highlights human and cultural factors. Different people inside and outside the org will have different views on what's a significant legal risk.
Different perspectives.
Exactly. And those views can be shaped by all sorts of things. You need to build awareness across your organization so everyone understands how their actions can create or, mitigate legal risk.
Get everyone on board.
Pretty much. And finally, like any good management system, continual improvement is key. Learning from the past, adopting best practices, staying on top of legal developments.
Standard practice for ISO, really.
It is. And specific to legal risk, the standard adds the principle of equity.
Equity. How does that fit in?
It's about making sure your decision-making is unbiased, that you're managing conflicts of interest fairly, and ensuring a sense of justice within your organization.
Interesting. So it's not just about following the letter of the law, but also the spirit of fairness.
That's a great way to put it.
Okay, so we know the principles. How does an organization actually do legal risk management on a practical level? What's the process look like?
Okay, the process. It kicks off with establishing context and criteria. We've touched on context quite a bit already.
The external and internal stuff.
Right. But a really important part here is defining your legal risk criteria. These are essentially your benchmarks, your measures for deciding what level of legal risk is acceptable for your organization. And they need to align with your objectives, your values, your resources, and importantly, your overall appetite for risk.
So in what kind of situations would these legal risk criteria really come into play? Where do they bite?
Well, the standard gives some helpful examples. Anything your organization is legally obligated to do or comply with or get approval for.
Right, the must-dos.
Yeah. Decisions that are legally reserved for your organization based on your policies or contracts. Situations that could lead to significant institutional liability or major compliance failures.
Like big data breaches.
Exactly. Government investigations, widespread violations of law, big data breaches, or lawsuits that are way outside the normal scope of your business. These are the kinds of things that should trigger your legal risk criteria.
Gotcha.
And it's crucial, really crucial, that these criteria aren't developed in a vacuum. They need to be linked to your overall risk criteria so you're not managing legal risks in a completely separate bubble.
Makes sense. Avoid the silo effect.
Okay.
Set the stage with context and criteria. What's the next act in this legal risk management play?
The next critical stage is assessment of legal risk. This is really the heart of the process, and it has three main parts: identification, analysis, and evaluation.
Okay, let's dive into identification first.
Yeah.
How do you actually go about finding and recognizing these potential legal risks before they become problems.
Right, identification. It's all about finding, recognizing, and clearly describing the potential legal risks that could either help you achieve your goals or, the opposite, prevent you from reaching them. This involves understanding where these risks might come from, what the potential consequences could be, what events might trigger them, and maybe what the root causes are.
So digging deep.
Yeah. You need to consider that broader context we talked about and any changes happening in the legal landscape. And a key point here is you should be looking for risks regardless of whether you have direct control over them or even if you know exactly what's causing them yet.
So cast a wide net. Where do you even start looking for these hidden legal landmines?
Well, there are a lot of potential sources. Obviously, the relevant laws and regulations themselves are the starting point.
Natural.
But you also need to look closely at the external and internal context we discussed. Talking to your stakeholders inside out can uncover potential risks. Your existing legal risk criteria, any legal risk management plans you already have, those are important. Even things like how you're required to keep records related to legal privilege or your data destruction policies, they can point to potential risks too.
Interesting.
The standard also emphasizes compliance obligations.
Compliance obligations, different from legal risks.
Slightly different, yeah. These are your commitments. Things like industry codes of conduct, agreements with community groups or government bodies, your own internal ethics policies, and of course, all your contracts.
So the obligation is the promise.
Exactly. The compliance obligation might be your promise to follow a certain industry code. The legal risk is what happens if you experience non-compliance with that code, maybe fines or reputational damage.
Got it. That distinction helps. It sounds like just staying in the know is half the battle here. How do you keep up with all these ever-changing legal rules and obligations?
It's absolutely crucial, yeah. The standard suggests a few ways. Subscribing to updates from regulators, joining professional associations, using legal info services.
Going to conferences.
Yeah, going to industry conferences, keeping an eye on government websites, tracking trends and lawsuits, and of course, working closely with your legal advisors.
Internal resources, too.
Definitely. Even doing internal legal audits and building your own database of legal knowledge can be really helpful. The key is just to have a systematic approach for spotting these changes and then figuring out how they might impact your organization.
Okay, so you've identified the risks, you've got your list. What happens in the analysis phase?
Analysis is where you really dig into those identified risks.
Yeah.
You're looking at how likely they are to happen and what the potential consequences could be if they do.
Likelihood and impact.
Precisely. This can be a qualitative assessment, sort of describing the potential impact in words, or quantitative, trying to put some numbers on it.
How do you do that?
Organizations might use past data, business analytics, maybe even AI and modeling these days, along with the insights of experts. It's worth remembering, though, you might get different opinions from different experts, so that's something to factor in.
Right.
Also, legal risks don't exist in isolation, do they? They can be linked to other types of risks within your organization, so you need to think about those connections as well.
Good point. And what sort of things influence how likely a legal risk is or how bad the consequences might be?
Well, several factors affect the likelihood. Think about the specific laws involved, how strictly they're enforced, how effective your current legal risk management system actually is, whether your employees follow the rules and internal policies.
Compliance culture.
Yeah, exactly. How often you engage in the activities that could trigger the risk, whether you've learned from past mistakes, even how you compare to others in your industry benchmarking.
And the consequences.
For consequences, you need to consider both the financial impact, like fines, settlements, and the non-financial impact.
Reputation.
Yeah, damage to your reputation, negative reactions from stakeholders, that sort of thing.
Right, so you've identified and analyzed the risks. Now comes evaluation. What's the goal here?
Evaluation is where you take the results of your risk analysis and compare them against those legal risk criteria we talked about earlier.
The benchmarks.
Exactly. This helps you figure out which risks are the most important, which ones need the most attention. It helps your decision makers understand the different options for dealing with them, which leads us nicely into the treatment phase.
Okay.
When you're evaluating, it's important to consider the bigger picture. Your organization's overall environment, your goals, your values, your comfort level with risk, your risk appetite, and your overall risk profile.
Makes sense. You can't put the same amount of effort into every single potential risk, can you?
Not realistically, no.
So let's talk about treatment of legal risk. What are the main ways an organization can actually deal with these prioritized risks?
Right, risk treatment. This is about developing and putting into action strategies to handle those legal risks you flagged as significant.
Okay.
The standard emphasizes looking at a range of options, not just legal fixes, but also financial, operational, even ways to protect your reputation.
So what are the options, like from ISO 31000?
Yeah. Drawing from the main standard, your options might include avoiding the risk altogether.
Just don't do the risky thing.
Pretty much. Or accepting it if it's maybe a low-impact risk. Modifying the risk maybe by changing your processes, sharing the risk.
Insurance, contract.
Exactly, perhaps through insurance or contracts. Or simply retaining the risk, but having a plan in place for what to do if it actually happens.
How do you decide which of those treatment options is the best fit for a particular risk, though?
Well, a thorough risk evaluation is essential before you choose your treatment. You need to be able to show you're managing these risks sensibly. The standard introduces this idea of key risk indicators, KRIs.
KRIs.
Yeah, think of KRIs like the dashboard in your car. The speedometer tells you how fast you're going.
Okay.
A legal KRI tells you how risky you are in a certain legal area.
You mean an example?
Okay, say, if you see a big spike in customer complaints about a certain product feature, that might be a KRI signaling a potential legal risk around product liability. Or you might look at the total potential liability in your contracts compared to the overall value of those contracts. Or maybe track how many employees have completed mandatory compliance training versus your total headcount. These data points help you see if your risk treatment strategies are actually working.
Those KRIs sound like a really practical way to monitor things. What other factors should you weigh up when deciding how to treat a legal risk?
You need to consider your organization's overall risk management policy, your strategic goals, your core values, your legal responsibilities.
The bigger picture again.
Always.
Yeah.
A cost-benefit analysis is usually a good idea. Think about how your stakeholders might view the risk, what their preferences are for handling it. What resources do you actually have available?
Budget people.
Yeah. You'll definitely want input from your legal team, maybe formal legal opinions. Can you transfer the risk through contracts or insurance? What's the general level of legal risk awareness across the organization? And it's also a really good idea to look at what you're already doing. How are you currently allocating resources? What does your legal counsel think before you even start developing a formal risk treatment plan?
Right. Assess the current state first. And what should that risk treatment plan actually look like? What should it include?
The plan should lay out specific policies and procedures, like how you'll handle notifications of legal disputes or your standard operating procedures for disclosing information. Exactly. It might include templates for reviewing contracts, measures for information security, strategies for reviewing and maybe redrafting contracts, methods you'll use for resolving disputes.
Training, too.
Absolutely. It should outline any training programs on relevant laws and the potential consequences of, not following them.
Okay.
And it's really important to remember that risk treatment isn't a set it and forget it thing. It's dynamic. It needs to be adjusted as things change.
Constantly evolving. Okay, we've assessed and treated the risks. What about keeping everyone in the loop? Making sure the right information gets to the right people. The standard mentions communication, consultation, and reporting.
Yes, this is absolutely vital. At every single stage, you need clear ways to communicate, both internally and externally.
But carefully, right? Confidentiality.
Always. Always being very careful to protect confidentiality and any legal privilege you might have. That's paramount. Timely communication and consultation with all your stakeholders, and that includes everyone from your employees right through to external regulators. Ensures everyone understands the legal risks involved and what their role is in making decisions.
And accepting they might see things differently.
Definitely. Remember that different stakeholders will often have different perspectives on risk. A strong process for monitoring and reviewing your risk management practices, along with good record keeping, is also essential.
Right.
And learning from everything you do in this process, that helps build a stronger culture of legal risk awareness over time.
What are some of the specific things you should be monitoring and reviewing then?
Well, you need to stay informed about changes in the legal landscape, obviously. Keep an eye on events that could trigger legal risks. Maybe track how often those events happen. Look for patterns.
What are the warnings?
Yeah, look for any early warning signs. You should also regularly check if your risk treatment strategies are actually working. Monitor changes in your overall business environment. Make sure your risk treatment plans are integrated with other plans.
And clearly define who is responsible and accountable for different aspects of legal risk management. And you should always compare your progress against your plan, and update it as needed.
And what about the record-keeping reporting side of things? Any key points to keep in mind there?
Yes, definitely. You need to be very aware of legal professional privilege, attorney-client privilege.
Super important.
Crucial. Your data protection policies will dictate how you handle storage, retention, destruction of records. Make sure your documentation is easily accessible, but only to those who need it for decision-making or audits.
Security.
Yes. You also need to think about whether certain documents need secure storage, maybe with audit trails to prevent unauthorized changes, and just generally have good confidentiality and security measures for sensitive info.
And reporting upwards.
Yes. Finally, you should regularly report on how you're implementing your legal risk management framework and whether you're actually sticking to the measures you've put in place. This all sounds like a pretty significant undertaking, implementing this whole system.
Yeah.
How do you actually go about implementing legal risk management within an organization? Making it stick.
Yeah, implementation. It's really about making legal risk management a natural part of how your organization operates day to day.
Not just a binder on a shelf.
Exactly. It needs to be integrated into your overall strategy, your risk management framework, your objectives, all your other management systems.
So what do you need for that?
Some key things for successful implementation. Having a clear written policy for legal risk management, assigning specific roles and responsibilities to people with the right skills and giving them the resources they need.
Right.
Establishing clear procedures for integrating legal considerations into all your key organizational processes. Allocating sufficient resources, a budget, time, people, and setting up those all-important communication channels we talked about.
So it's about embedding it everywhere.
Pretty much. Making sure everyone in the organization understands legal risks through ongoing training and communication. It's a culture thing, really.
Okay. Now, the standard also has some helpful annexes at the end, doesn't it? Can you give us a quick rundown of some of the practical tools they suggest? Maybe Annex A.
Absolutely. The annexes provide some really useful practical frameworks. Annex A introduces the Legal Risk Identification Matrix, or LRIM.
LRM, okay.
This is basically a structured way to think about the types of legal risks you might face in different parts of your business.
Types, like what?
Well, for example, are you worried about breaking the law? That would fall under non-compliance. Or maybe you're concerned about not protecting your own rights. That could be omission in exercising rights.
I see. Categories.
Exactly. It outlines 6 main categories of legal risk and also highlights red flags within each category, things that should immediately make you think, hang on a minute.
That sounds like a good way to get a handle on the different flavors of legal risk across the whole organization. What else is in the annexes? Annex B?
Annex B gives an example of a legal risk register.
The register. Classic risk tool.
It is. This is essentially a list where you keep track of potential legal risk events, the specific laws that might apply, and the possible consequences if those risks materialize.
Mm-hmm.
It's really important, though, to involve your legal team when you're creating and maintaining this to make sure you're protecting legal privilege.
Crucial point again.
Yes. The annex also includes sample questions you can use when talking to different teams within your organization, helps you understand their legal risk exposures and how well they think they're managing them.
A risk register sounds pretty fundamental for keeping track of all this. What about actually figuring out how likely these risks are or how bad they might be?
Yeah.
Annex C and D.
Right. Annex C provides an example of how to estimate the likelihood of legal risk events.
Okay. Oh.
It suggests a sort of 2-step process. First, could this event even happen? And second, if it did, would it have legal consequences? It gives you a rating scale based on things like how good your risk management policies are, how well employees are trained, the risk associated with counterparties you deal with, how easily laws can be enforced, how often you do the risky activity, things like that.
Okay, so that's likelihood. What about Annex D, consequences?
Exactly. Annex D then offers a way to estimate the consequences of legal risk events. It looks at different types of impacts, financial, regulatory, reputational, geographical, even internal organizational impacts.
A whole spectrum.
Yeah, and it uses a scale from basically no consequence all the way up to severe consequence. It emphasizes that you need to customize how you weigh these different types of consequences based on what's most important to your organization.
So Annex C helps you figure out if it might happen, and Annex D helps figure out how bad it might be if it does.
That's a perfect summary. It's a really useful combination for prioritizing where to focus your efforts.
Definitely sounds like it. And the last annex, Annex E, is all about contracts, right?
Exactly. Annex E provides a checklist a really helpful checklist of key clauses to think about when you're reviewing contracts to minimize your legal risk.
For any contract?
Pretty much. It looks at things from both sides, whether you're the vendor or the purchaser.
Okay.
And it covers a really wide range of important areas. Things like, does everyone have the legal authority to sign this? Payment terms, delivery details, when ownership transfers.
Cancellation, termination.
Yep. Cancellation, termination, damages, liability, confidentiality. What happens if someone goes insolvent? Which country's laws apply?
Warranties.
Indemnities.
All those tricky ones. Warranties, indemnities where you agree to cover the other party's losses. Can you assign the contract? Force majeure, those unforeseen events.
Dispute resolution.
Dispute resolution methods, third-party rights, automatic renewals, watch out for those. How you make changes, data protection and privacy, huge these days. Location of data. Ownership.
All of that. Location, ownership of data, insurance requirements, time limits on claims. It even touches on ethical issues and making sure you're not accidentally violating the other party's internal policies.
Wow.
It's a really comprehensive list. Things to consider every single time you're looking at a contract. Think about, those phone contracts that lock you in for years with massive cancellation fees. That's the kind of unfavorable agreement the standard is talking about, and this checklist helps you spot those potential pitfalls before you sign.
That contract checklist alone sounds incredibly valuable for anyone who deals with agreements day to day.
It really is.
Okay, so to sort of bring it all together then, what are the main things we and the listeners should take away from our deep dive into ISO 31022 today?
I think the core message is that legal risk is much broader than just, avoiding lawsuits.
Right.
Effectively managing it requires a systematic, proactive, and integrated approach. It's not an add-on. That means really understanding your organization's unique situation, that context piece, following the key principles we talked about, going through that structured process. Context, assessment, treatment, communication, monitoring.
Whole cycle.
The whole cycle. And using practical tools like risk matrices and registers to help you stay organized and focused.
Right. And the goal here isn't, as you said, to become a legal expert overnight, but more to gain a solid understanding so we can ask better questions, maybe make smarter decisions.
Exactly.
And ultimately help our organizations be more resilient and, successful.
Precisely. So maybe here's something for you, the listener, to think about. Based on the principles and steps we've discussed today, take a moment later on. Try and identify just one potential legal risk within your current work or maybe an area of interest. And then ask yourself, how does my organization currently handle something like that? Does it seem to align with what we've talked about from ISO 31022?
Just a quick reflection.
Yeah, even that simple exercise can be a really powerful way to start thinking more deeply about this. And of course, if you want to explore this in even more detail, the ISO 31822 standard itself is a fantastic resource to really dig into further.